second shift of the Fourth Circuit today. And Mr. Kamens, the
Good
boss
morning,
man of
Good
it
morning,
all. Good to have you with us, sir.
Thank you. I'm very happy to be here. May it please the court, when a defendant is imprisoned in a foreign country with a valid extradition treaty with the United States, where extradition is the only viable means of obtaining custody of that individual, the failure to seek extradition is delay which is attributable to the government for purposes of the Sixth Amendment speedy trial right, unless seeking extradition would be completely futile. But futility cannot be assumed. The Supreme Court's decision in Smith versus Huey establishes an affirmative duty on the government after filing charges to make a serious effort to obtain custody. And it noted that the possibility of refusal is not equivalent to asking and receiving a rebuff.
How do you define, you said only viable means. How do we know what's the line, what's the definition, what's the principle that determines viable means?
Well, it's got to be based on the record. In this case, the record is very clear that Mr. Chaudhry, Umar Chaudhry, our client, is a dual citizen of Pakistan and the United States. And when he was held in Pakistan by Pakistani authorities, there is no way to obtain custody of Mr. Chaudhry by having Pakistan deport him because he is a citizen. It is a principle that is universally understood both in the United States and around the world that countries, almost every country, does not deport their own citizens. That is, deportation is reserved.
Is it your belief that the interaction that went on in this case that I guess would be under the umbrella of deportation is something other than extradition?
That's true, and the government said that below as well, that they made a single diplomatic note. It's dated January 15th.
Well, they may have made a single diplomatic note, but there was a good bit of back and forth, about whether that would happen or not happen, and there was no express statement that, look, we're not going to do that for some period of time. And so that's what I'm getting at. I appreciate your principle that deportation may have been unlikely, may not have been permitted, but the extradition says shall not extradite pending charges, and so I think we're dealing with two things that there might be not a great likelihood, but a possibility of, and so I'm just trying to figure out why what they were pursuing isn't viable, I guess.
And it wasn't viable because Mr. Chaudhry is a citizen of Pakistan, and so asking Pakistan to deport one of his own citizens would have violated the Pakistani constitution. It's in the blue brief, we've cited it. It's
Right,
also a universal
that.
principle.
I appreciate
There's no indication in the record that you adverted to Article 4 of the extradition treaty.
Yes, sir.
There's nothing in the record to suggest that in 2010 or thereafter, the United States looked at the extradition treaty and said, oh my gosh, look at Article 4, we got to sit around and wait on our hands. The only thing they did is issued a single diplomatic note. And you're right, there was additional back and forth. There was a meeting in June of 2010. I've learned that there is a difference in terms of diplomatic communications about the formality with which a country communicates with another. So the State Department helpfully provided a timeline of their efforts in this case. It's on page 392 of the Joint Appendix, and it lists that single diplomatic note from January 15th of 2010, and the next entry is 2019. So essentially between 2010 and 2019, the government did nothing other than send that diplomatic note asking for deportation. The government has two principal arguments here. Well, let me say first that the Supreme Court has clearly set forth the principle that the government has the duty to make a serious effort to obtain an individual who is in custody of another sovereign. The district court erred in denying the motion to dismiss because the government made no serious effort. Now, the government has two principal arguments against relief in this case. One of them, Judge Quattlebaum, is the Article 4 that you adverted to. The other is that because extradition from Pakistan takes a long time and rarely is successful, that the government's requests for deportation were sufficient to constitute a serious effort to
He was in
obtain
prison,
custody.
though, wasn't
Sorry, Your
he?
Honor?
He was in prison.
He was in prison. That's true. And even when an individual who's been charged in the United States is in prison by another sovereign, the government still has the duty to try. That is, to make a request for their return.
Well, is trying enough? Because I thought your contention was they didn't make a formal extradition request. I mean, the record seems to indicate they tried.
So-
And did some things there. I mean, you had numerous opportunities. You had the ambassador meet with him, the legal attaché. They made the efforts there, but here's the question that I guess is sort of interesting to me. I think you say that Pakistan manufactured the charges against them. That would seem to suggest me, if they would do that, why in the world would they extradite him? I mean, why would they deport him? If it almost seems like it'd be futile if you did ask for it, because you say they obviously just wanted to prosecute it.
So absolutely, there's evidence in the record, completely manufactured charges in Pakistan. But what, Judge, when you're asking is, what would Pakistan have done if the United States had asked them to extradite? And we don't know. It's possible they could have refused, but that's the lesson that we have from Smith versus Huey, that the possibility of refusal is not the same as making the request. Now, I want to be absolutely clear here. We are not asking this court, and we don't believe it's consistent with the law, that there is a bright line rule that every time an individual is overseas held by another sovereign, the U.S. has to make an extradition request. The standard is a serious effort to obtain custody or exercising reasonable diligence.
What was he charged for in Pakistan?
It was conspiracy to attack Pakistani military bases and a nuclear facility.
And he was charged in the United States with?
Conspiracy to provide material support to a designated terrorist group, Jaish-e-Mohammed, J-E-M. So they're comparable.
I mean, it sounds kind of kin to me.
It does.
You would think that, it doesn't sound so manufactured to me. You either would have to prove the evidence, and I don't want to challenge the Pakistani legal system. I'm assuming you've got the same kind of rights, so you got rights there too. But they went through a trial process, and the charge itself doesn't sound like it's far-fetched, because it's sort of similar to what the United States wanted to charge him with. And he was in Pakistan. That's the key.
That's the key.
He left from
Absolutely.
here. From here, he went to Pakistan, and the actions are taking place for the U.S. military in Pakistan.
And they convicted, he was convicted
And he was convicted.
and sentenced to 10 years?
And he was sentenced to 10 years along with his four compatriots. Let me say two things. One, the sort of legal implication, if that were true, and then the facts of what actually happened. So the legal implication is, if the Pakistani charges were akin, as Judge Wynn, you just said, they were similar
Aren't
to the...
they? I mean, if you
The-
say they say he was going to deal with the Pakistani military, which is more likely because you got the military, the United States, in the United States, so you're going there to deal with the United States military. You got to first get to them, and you got to deal with it. So, I mean, it seems
If they
just
were,
as plausible to me as it does for the United States military.
if the charges were related, then Article 4 of the treaty says that the delay is only until the conclusion of the Pakistani prosecution and not until the conclusion of the sentence. So if that were actually true, and if the government believed that was true, that the charges were the same, then Article 4 would not allow
When was our
deferral.
charge lodged?
Our charge was issued, I think it's December 29th of 2009. That's the complaint, warrant, and an international red notice related to the complaint, asking Interpol to tell Interpol countries to arrest an individual. And that relates to the...
Was indicted when?
He was indicted in 2017, I believe it was November of 2017. I can clear up just briefly the first Barker versus Wingo factor, which is when does the speedy trial clock start ticking? It's very clear it starts when, as this court said in Thomas and a case called Wolfick, when the complaint and arrest warrant, international red notice were issued in December of 2009. Now, the government disputed that below. On appeal, they've essentially abandoned that argument.
Basically, that's the length of the delay.
That's the length of the delay. So
The
from,
government pretty much acknowledges you can establish that factor. I think.
they do, but it's a two-part inquiry. So the first thing that they acknowledge is that the delay triggers judicial review, and that's only a delay that
But
requires
it's the
8
reason
to.
for the delay, that's the problem.
The reason for the delay is the second Parker factor. It's very important, but the length of the delay is also really important. So we say the length is 10 years. And the government says, well, you don't need to decide that, but you do. It's clear that under the first factor, you have to decide both parts. One, is there a sufficient delay to require judicial review? Government agrees on that. And then the second is, how long is the delay? The delay here, we argue, from 2009 until the trial date was set, 2024. Now, there's
Well, it wouldn't matter if it was 10 years or 20 years if the reason for it was satisfied, would it?
Well, let's see, let me parse that. It
Well,
would,
I mean, I'm saying, if you can establish, government can establish a reason why it was 20 years, it could have been that Pakistan says, no, you, no need you submit us anything. We're gonna keep you here for 20 years in this jail right here. It wouldn't have mattered.
that's
that it was
absolutely
20
right.
years.
So if the government had a statement from Pakistan, hey, we're not gonna deport you, we're not gonna extradite this individual, that would be a showing of futility. That's what the cases say. If the country says, we're not deporting individual charged with drug offenses, or you don't have a valid extraditable offense, or we're not gonna extradite this individual, then that's futility.
So I'm only asking this because I just want you to help get my mind off of this business that he's charged with attempting to, gonna do something to the Pakistani military. And then it seems to me, if you had a reverse situation of a Pakistani who had dual citizen in Pakistan, who came to the United States, and he's charged here with U.S. military, I can't imagine we would send him back before that sentence is done. I cannot imagine. And I can't imagine Pakistan is gonna do that once you are convicted of doing something to our military, we're gonna send you somewhere else to be tried. That sounds like it's futile to me.
Well, it's certainly fair, although it is up to the sovereign to decide the timing of surrender. So it is absolutely the case that we would go through our process and impose a sentence. But then if the government decided, well, we want this other country to be able to engage in their process, the executive branch gets to decide whether to enforce a provision. So we cited,
But if it was he was shoplifting or he jaywalked or maybe spit on the side of the highway in Singapore or something like that, that's one thing. But this charge is, he's attempting to do something to the Pakistani military, and he's convicted of it in Pakistan. And you say it's not futile for another country to say, why don't you just release him and send him to us, where he could be found innocent of stuff, then you got to figure out how to get him back to do that. I mean,
well, the law is you have to ask. You can't just wait on your hands and assume what the answer is.
Is your
Now,
position that the nature of the charges or the conviction doesn't have anything to do with it?
it doesn't actually, I mean, unless it's not an extraditable offense.
That doesn't make any sense.
Well, let me be clear. So the speedy
Based on
trial,
what Judge Wynn just said, the comparison he made, I mean, that the nature of the charges wouldn't make any sense.
well,
This
again,
is terrorism. It wasn't lingering on the side of the road or something.
the government can't assume that Pakistan will deny it's a lawful extradition if we make the request. An
But
extradition
they're
is an
not-
order.
They're not assuming that. Maybe they could assume, maybe futility is there, but even if it's not futile, I mean, they've spent a decent amount of time. Judge Wynn talked about some of the efforts they've made. They've gotten, really, and they've got the history of having, requested extradition before, without success. And so, and then, he's convicted and is in jail, and they start interacting again when they hear the sentence might be coming up, and have a lot of effort and activity going on there. It just seems to me it's hard to say they're not actively engaged in trying to get him back before and after his conviction.
So that assumes that deportation is a way to get him, but it's not. And the government can't assume that Pakistan will deny a request for extradition. That's the lesson of Smith versus Dewey. So in that case, Texas assumed that the Federal Bureau of Prisons wouldn't send the defendant from BOP custody to face trial in Texas. but that's not what the speedy trial right requires. They have to ask if there's a viable extradition treaty and the claim is extraditable. Now, we can all assume that Pakistan may say, nope, we're going to keep this person here. But in this case, this was a completely sham prosecution. The evidence is in the record below. And all Pakistan wanted from the prosecution was a propaganda value that may have been satisfied by the
Which
trial.
prosecution was a sham prosecution?
The one in Pakistan.
The one in Pakistan
That's
was
right.
a sham prosecution.
That's right, with false
The
evidence.
one in Virginia was not a sham prosecution.
No, I don't think it was.
But, he didn't get any sentence.
Well,
He walked.
if I can respond, my
It
time
wasn't
is
just a
up.
prosecution in Pakistan, it was a
Yeah.
trial and a conviction. So you're saying the whole process was a sham, not just the charges. You're saying that the judge was a part of the sham, the trial process was a whole, and the ultimate system was a sham. So you're saying the whole system was a sham.
So my time's up, but can I
You go
explain?
ahead, and- as long as you get questions.
Oh, yeah.
You know
So-
the answer.
So this is in the briefing, but essentially the United States at this time was criticizing Pakistani intelligence for supporting the Taliban and anti-United States forces in Afghanistan. And so to respond to that, you had these 5 Americans who, by every piece of evidence that we ever received from the government, were intending to go to Pakistan so they could go to Afghanistan and help Muslims and potentially fight against U.S. troops there.
But
And-
they were convicted of doing more. They went there to terrorize the American military there.
Not American military in Pakistan. The Pakistanis said these
But
Americans.
that's their intent of going there. It wasn't just they weren't a Red Cross or a nice little aid group that was going over there. They were going over there to do some terrorism, whether it was in Pakistan, Afghanistan, to American forces.
Well, terrorism is a loaded term. So the
Well, that's
intent.
the conviction. The conviction is that.
If we're talking about the United States prosecution, that was about going to Afghanistan.
That
The-
wasn't a sham. You made that clear.
It was not.
That
And
was clear.
that's
But
true.
that one they did in Pakistan.
Right. Pakistan was
you think
about
was.
these 5 individuals. Pakistan prosecuted them for essentially being U.S. agents to come and commit terrorism in Pakistan against the Pakistani
That was
military.
2010.
And that was 2010, and it was a complete sham, and it was for propaganda value, and the evidence was fraudulent, and that's in the record. And here's the other information is, my friend on the other side, both below and in these briefs, has never denied that the Pakistani prosecution was completely fraudulent. And so there are certainly cases where the United States can stand back and say, we have no interest in interfering with another sovereign's prosecution. We've made a considered judgment not to interfere. That's not what happened on this case. In this case, the government had no interest in waiting by for Pakistan to engage in this completely sham process that they knew was a sham. And that's why they've never,
But does I think Judge Wynn may have asked about this earlier. I mean, does that sham issue cut both ways? I mean, let's assume we agree with you that they've engaged in a propaganda-based trial. And that's a pretty serious thing. But let's assume that they're willing to go to those lengths to engage in a totally fictitious trial and lock one of their citizens up for 10 years. And, you know, and you're saying it's not reasonable, our government, it's reasonable to believe that the government that engages in that sham process is going to say, all right, here's this, convicted citizen, go ahead and extradite him. I mean, it seems like the sham stuff may hurt you more than it helps you.
so you make a good point. It's very possible that Pakistan could have said, no, we're rejecting your request for extradition, but the possibility of refusal is not the same as making the request and getting a rebuff.
But
So
possibility, is one thing. I mean, I think you're right. You can't just sit there and say, well, it's possible. But all signs here, all of them, I mean, history, what they've dealt with before, their efforts to get him both through deportation, and then this sham stuff, it seems to me that's more of a possibility. It seems like it's a high probability.
So
And-
essentially, you're saying that it was futile, right? But this court would be going beyond where any court of appeals has said futility is. So if you look at page 38 of the red brief, they list 5 cases where they say If it's futile, you don't have to ask for extradition.
Right.
Every one of them, and I encourage you to look at every one, they are in cases where the other country has said we're not extraditing that individual, or they are charged with an offense that's not extraditable under the treaty, or we're not extraditing drug defendants, or we're not extraditing citizens of the country. Every one of them, absolutely clear cut. In this case, the government says itself that extradition has been successful. There was one that was successful in 2015, one in 2021. This client, Mr. Chaudhry, was successfully extradited. His co-defendant was just successfully extradited about a month ago. That I can submit a 28J, but it's in the district court docket because he made his Rule 5 appearance. So it's not as if extradition was futile in this case. And if it's not futile,
He was extradited after he was tried, charged, and sentenced.
That's
and
true.
Served his sentence.
absolutely, but still,
And he served his time. Was that legitimate time?
he served an incredibly difficult 10 years in horrific
So he was
conditions in
actually-
Pakistan.
He was actually in the penitentiary or someplace.
Absolutely, for 4 years in a very high
He just
security.
wasn't running loose on supervised release.
No, he was absolutely, and that's, of course, why my friends on the other side agreed to the resolution of this case that they did, and we certainly appreciate that. But the point is, it was incumbent upon the United States to make a request for extradition because it wasn't
Well,
futile.
and you made a deal to get him no time here.
That's true. We entered a conditional plea, and the government and the defendant jointly recommended a sentence of time served and 20 years of supervised
Time served.
release.
I mean, he's pretty lucky.
Well, if you can call 10 years in high-security Pakistani
He'd already
prison,
done that, and he was facing more here.
that's true. And I think that,
And you're working magic.
well, I think that the government recognized there was no more need for any deterrence against this individual. And so that's why, if the court were to grant relief in this case, it's no skin off the government's nose.
I bet they'll say they had a good case against him.
They may, of course, but that's not the question before this court. So I would just say that the Supreme Court has said that the more weight the government
Well, he was
attaches,
charged with terrorism. They had to go to a grand jury and convince him. There was probable cause to charge him with aiding terrorism or however you characterize the thing.
absolutely,
That's a tough charge.
absolutely. And there's no doubt that the government had a good faith basis to bring the charge
And
they
he
did.
walked on it.
Well, I wouldn't say
That's-
walked. He has a
I've
felony.
never heard of this before.
Well,
I mean, I've been around a lot of criminal cases.
thank you, Your Honor. We did.
Over the years.
The sentencing memos in the.
You did the best I've ever seen, or heard of.
Thank you. The road was paved by two co-defendants before me.
And now you're trying to get him out under this.
Well, I think this morning you heard that the Supreme Court had issued a decision already in the case that you'd heard this morning. The Supreme Court hasn't.
Yeah, let's stay from this moment. Let's stay right here.
Right. The Supreme Court hasn't issued a decision in this particular case, but it's come close in Doggett. In Doggett, the.
Judge Wynn's gonna start arguing about preliminary injunctions. That's right. You don't watch out.
What our opinion is.
The Supreme Court issued an opinion in Doggett where the government in that case, they knew that a defendant had gone to Panama, and the agent just said, well, it's futile to seek extradition, so I'm just going to ask Panama to return him and deport him at the end. And they didn't, and the guy came back into the country, and they didn't do anything for another 8.5 years. Doggett's very close to this case. The last thing I'll say is that the government's principal argument here is that it was really hard to seek extradition, and they lose a lot. And to me, that's very familiar to federal defenders coming before this court. It's very hard, and we lose a lot, but it doesn't mean that we don't have to try and exercise as much effort as we possibly can. And that's what my friends on the other side had to do with respect to Mr.
But
Chaudhry.
that's an interesting analogy, and I appreciate what you do, by the way. So, and you do it well. We're not joking about that. But I think in the reasonableness, the standard might be a little different, or it might be that you don't have to pull out every single stop, do everything imaginable. You just have to exercise an appropriate level of effort. So I think,
Absolutely agree.
I think doing everything you can if that was the standard, we might have one thing, but if the standard is something less than that, then maybe it's a different question.
Absolutely agree, Judge Quattlebaum, but asking another country to deport one of its own citizens isn't a reasonable way to get custody of that defendant.
I understand your position. Thank you.
Thank you.
Thank you. And you reserved some time. We gave you a lot of extra time.
Thank you.
Yeah, you hit the jackpot. Mr. Matias, good to have you, sir.
Thank you, Judge King. Good morning. May it please the court. Your Honors, the crux of this appeal, as we heard this morning, is the second Barker factor. That's the reason for the delay. And distilled down to its essence, there are two key reasons for the delay in this case. The one, which is most obviously the defendant was arrested, prosecuted, and convicted, and then sentenced to a decade in prison in Pakistan.
What does it take to make a formal extradition request? You just ask?
Not exactly, Your Honor. The declaration from our expert, Jeff Olson, paragraphs 8 to 12, around 8 to 12, describe the process. It starts within DOJ, it then moves to the State Department, it then gets certified at very high levels within the State Department, it then goes to Pakistan, goes through their political levels, it then ends up in the courts, and then once it's in the courts, it can be challenged, and these proceedings can take.
But it starts in the U.S. Attorney's Office?
It starts in the U.S. Attorney's Office in combination with an office within the Department of Justice.
Is
Then
there a
goes to the State
reason-
Department.
But what's the reason you didn't seek extradition?
Sure. So two main reasons here. So number one is that Article 4 of the extradition treaty provides that extradition shall be deferred until the completion of the trial and the full execution of the sentence. So
Completion
that's
of the
just
trial.
full execution of the completion of the trial and then the full execution of the punishment.
Full execution.
Full
That's-
execution of the
all right.
punishment.
So your colleague says there's no indication y'all considered that's just in the record and you're doing it now for litigation purposes, but there's no indication that was the actual reason. I think he said something to that effect. You got a before you go to your second reason, do you have an answer on that?
Sure. So our expert, Jeff Olson, explained that based on their experience with Pakistan, his office's experience with Pakistan, they would frequently advise prosecutors to seek the informal route as a general matter. And then there are two places in his affidavit where he explained that they read Article 4, and it's written in past tense, that Article 4 obliged them to wait until after his sentence
Is that because, I mean, I'm trying to figure out why is it better to go informally? Is it, is there a greater chance of, is the thought that there's a greater chance of success if you don't have an official decision like an extradition decision? I mean, why is one better than the other?
I think that's right. I mean, our expert, Jeff Olson, explained that extradition from Pakistan was basically the exception and not the norm, and that in the majority of the cases, extradition would go unanswered, the requests were misplaced, they would have to be resubmitted, and that most were not even answered at all, and that there was what they viewed as an expedited option where we could submit basically something like this informal note. It basically cuts out the court element and some of the other political levels, I believe, political levels of review. It still has to be certified at a political level, though.
But here, what's interesting about this case is he's a citizen of both the United States and Pakistan. I'd go on a limb and said he probably was originally a citizen of Pakistan, and then he's been naturalized here. There've been some efforts that I've been understanding is how you unnaturalize a person, but neither here nor there. I'm not trying to say one is more important than the other, but why? I mean, he's a citizen of Pakistan, so why would they extradite him, even if there is a formal request? You don't have to. It's our citizen. And he says, well, it's our citizen equal, but he says, well, he was our citizen first, and he's here attacking us. So is that a factor, the fact that he was, would it be different if he was only a citizen of the United States?
So the reason why we sought the deportation.
Is the answer to that question yes or no?
Not really. I mean, the reason, well, yeah, it matters in the sense that we would not have asked Pakistan, we would not have moved through the informal route had he only been a Pakistani citizen. The reason we
The
asked,
question is, had he only been a United States citizen? he's only a United States citizen and he does the same thing, what he's doing, is that do you take a different approach with that?
I don't think so, Your Honor. I think with a United States citizen, we would have wanted him back. If he was just a United States citizen or a dual citizen, we're always gonna take the
So you're
option that we
saying
think
the
is the
fact he
most,
was a Pakistani citizen doesn't make any difference?
for our request or for Pakistan's purposes?
Well, for you, what you're doing.
Well,
Your request.
it matters in the sense that we sought the deportation option because he was both a US citizen and a Pakistani citizen. That option is the more expedited option, and it was one that Pakistan, at least in principle, and I'd like to,
The question is, can Pakistan legally deport one of its own citizens?
sure, so I think the answer on this record is yes, and I can point the court to two places. Number one, which is the very first meeting that we had on December 15th with Pakistan, that's where the ALAT meets the Director General, and they discuss how to seek custody of the defendant. And the government representative
And
asked,
deport is the same as extradite.
not exactly, I mean,
That's because my question was, can you deport him?
yes.
Not
and-
the
and-
extradite.
And, well, you can certainly extradite, and the answer, I think, also is on this record, that Pakistan, at least in principle, had no objections until 2020
So you're
to
telling me
deporting.
Pakistan has deported its own citizens to another country?
I can't tell you what they've done previously to other countries, I can only tell you what's in this record.
Have we deported any of our citizens to another country?
I don't believe so.
So the argument though is, it sounds like, you know, the US hasn't done it, you don't have any evidence Pakistan has done it, but the interactions that you had here led you to believe Pakistan was considering it?
That's exactly right, and if you go to the record, and this is JA 114, that's the record of the interaction I was just describing, that's the very first meeting we had after the defendants were arrested, extradition is raised, we then respond and say, would Pakistan be willing to deport? And the response that we get from the Director General is, quote, it's possible, harder now that the intelligence services are involved, but that is possible, and that we should get our request in soon, and then follow it up with a high-level sort of follow-up from the US ambassador, which is exactly what we did. And then on June 18th, and this is when the trial this is mid-trial in Pakistan, there's another conversation between another government representative and the Pakistani Ministry of the Interior, where we ask if they can continue to hold the defendants briefly and suspend their visas just in case they're acquitted, and then we could deport them, and then Pakistan would deport them, and the response, at least in principle, was yes, and that's JA 165. And so all the indications that we're getting from Pakistan, at least initially, are, I mean, there's certainly no objection, and the response is, it's possible, you should pursue it, do it fast, basically. It's only until 2020, when the defendant is close to finishing up his sentence, that they come back to us and say, we're not gonna do this for 2 defendants, we'll extradite to 3 US citizens, and then he's released, and then what do? Exactly consistent with Article 4 is they come to us and they ask us for extradition papers, which is basically what totally tracks the extradition treaty, which says the extradition shall be deferred until the completion of the sentence.
So at the end of the day, still in your case, is it your position that the numerous examples that are set forth where the diplomatic efforts were made by the United States through its legal attaché, its ambassador and the consulate to Islamabad, that those efforts demonstrate that it's sufficient to meet that reasonable diligence requirement under the Constitution?
Absolutely, Your Honor.
Anything else to your position that follows beyond that?
No, Your Honor. I mean, our position here is that and it was the district court's view also, the standard that courts of appeals have sort of coalesced around is due diligence or reasonable diligence. The district court concluded
So
here that.
nothing else you have goes beyond that determination right there. In other words, that basically sums up your position.
That's exactly right. As the district court concluded, the government made extensive reasonable efforts to seek custody of the defendant.
Okay.
Your Honor, I'd be happy to address the assertion of the right or the prejudice factor if the court has any questions. Otherwise,
How come you let him off so easy?
well, that was not my decision, Your Honor. That was the
Well,
decision.
you're the government.
That,
You're the United States government. The prosecutor.
That's right, Your Honor. I'll agree with you that this is exceedingly rare for a defendant to get a sentence. I have never seen this happen before, for a defendant to get extradited, come back, and then get no time at all. I think in part, it's a recognition of the sentence he served there. I'm not doubting that.
Well, if you're going to do all that, why didn't you take care of this issue with the plea agreement and the agreement to let him walk?
I'm sorry, Your Honor.
Why didn't you take care of this, have him waive any further litigation about the thing?
Sure, and
You were letting him off the hook
that's right. That's right.
completely.
Yeah, no,
Except that then you left yourself having to do this work.
Sure, that's another thing that's exceedingly rare, is to let the defendant conditionally plea. This court actually doesn't really have any clear precedent that tracks these facts, and most of the reason why there's so many out-of-circuit cases in our brief is because
This is a unique set of facts.
this is a unique set of facts, and as far as I'm aware,
So we're plowing a new furrow.
a little bit. There's some guidance from other courts of appeals and the Supreme Court, but I'd say this is pretty close to an issue of first impression.
Do you have any, from your standpoint, there's been this argument that this prosecution and sentence and everything that he had in Pakistan was a sham. How's that, I mean, what's your position on that? What do we make of that? He says you don't dispute it. Is it that you don't you agree with that, or you're just assuming it and it doesn't make any difference? Tell me what we're
Sure.
supposed to do from the government standpoint about that argument.
I think you're supposed to do nothing with it because it's just pure speculation that's completely untethered to the record.
Finding of fact the trial court made or anybody else, no one's made that as a finding
That-
of fact.
that-
That's just something you just think.
Well, that's right. I
I'm sure the
mean,
United States is gonna say that, and then the public, I'm pretty sure it's not gonna say that.
well, it's just speculation. I have no reason when I look at the record
Yeah.
to tell you, yes, Your Honor, this was a sham
It's
prosecution.
speculation to say it's a sham set of facts?
That's right.
Is that what you're saying?
That's
Well,
right.
normally, it wouldn't think it was a sham when the guy goes to the penitentiary for 10 years.
I agree with that, and there are certainly mechanisms, I
Now,
think.
it'd be a sham set of facts when he pleads guilty to terrorism and walks out of the courtroom. That might look like more of the sham.
I understand that. The EDVA prosecution was not a sham, though, but I understand Your Honor's point. All right. Thank you, Your Honors.
Thank you very much. We appreciate you. Mr. Kamen?
First, let me talk about the sham. The evidence in the records at JA 293, that's a declaration from Mr. Chaudhry's father who attended the trial and submitted a declaration to the district court saying that he observed fraudulent evidence being admitted, witnesses testifying that he knew Mr. Chaudhry's family and it was about him.
What did the trial court do with that? Did it make a finding of fact that,
It did, and the findings of fact are in the
was the
sealed.
finding of fact that it was a sham?
Oh, no, the district court did not. The district court decision was before
It was
that
his father
declaration.
that went there and said it was a sham. I probably heard that a few times here in the United States. A parent go and say, it looked like a sham to me.
Fair enough.
Most times the defendant says it.
Well, let me say this again. If it wasn't a sham, if there was real evidence of it, the Pakistani authorities accused Mr. Chaudhry of providing money to Jaish-e-Mohammed, the same group that's involved in the offensive conviction. If that were true, the government would have provided it in discovery. It would be in the statement of facts. That the defendant submitted an amount of money of 200 rupees to Jaish-e-Mohammed, and Jaish-e-Mohammed submitted a receipt. The proof in Pakistan was that all 5 defendants got receipts from this banned organization in Pakistan. That's not part of the discovery I received from the U.S. government. It's not part of the statement of facts on the offensive conviction, and it's because it's completely fraudulent. The government knew it, everybody knew it, but Pakistan had its own interest for pursuing that
I
prosecution.
heard Judge Qualibon mention to you that whole business of whether it was a sham, there is something that cuts both ways on it.
Certainly, but again, the law is that we can't.
Pushing it, it depends on how it cut for you. Pushing it may or may not help.
But again, from the speedy trial right perspective, we can't assume what Pakistan's answer would be. It compels the conclusion that the U.S. had no considered interest in waiting until Pakistan proceeded with its judicial process. That's why initially the U.S. asked Pakistan to deport these individuals immediately and forego the Pakistani process. Pointing to that communication, which my friend just did, JA 114, a Pakistani diplomat, and that's a communication, it's a readout of a communication from the Pakistani Ministry of Interior, where the diplomat said, the government of Pakistan will want the U.S. government to follow the formal extradition process. The request from Pakistan in December of 2009 was for the United States to ask for extradition, and the U.S. didn't. And why did they not? Because my friend says, Mr. Olson from the OIA, Office of International Affairs, said it's hard.
What sentence did he face in the United States for the charges?
Well, I believe at that time the maximum for material support is 15 years. It's now changed to 20. I think the maximum was 15
You have
years.
some reason to believe he would have gotten less than 10 here?
Well, I mean, given the current circumstances where he had horrific imprisonment in
I'm saying the
Pakistan.
conditions, I'm talking about the fact of imprisonment. I understand that you might be complaining he wasn't treated in the same manner as the United States prison, so that's a whole different argument. But if it's the sentence of 10 years,
Well,
and he would have gotten 10 years here, your complaint is it would have been in a different situation and maybe more humane, but is he, I don't know, what is his condition now? I mean, is he?
let me say this, that material support cases come in a wide variety of flavors, and there are people who are really dangerous and really committed, and then you have a bunch of jihadi wannabes and people who have no
I'm not trying to
training.
make it sound like it's the same. I will accept that it probably is much different there. I'm just talking about the sentence itself.
And-
If he was, because initially, when he was there, did you fight? Wasn't he against extradition at the beginning?
He did oppose extradition once he's
He
released.
didn't want to be extradited.
Well, that's
And
true.
he's a Pakistani citizen. Sort of reminds me of Paul saying, "I'm a Roman. I want to be tried by the Romans, not by the by the Hebrew system." Biblical thing. But anyway.
No.
But so he's there. He declares, "I'm Pakistani. I don't want to be tried in a Pakistani court. I don't want to be extradited."
No, they're
Does
important.
he have a right to do that?
He has a right to defend himself in extradition, and there are important rights that you can obtain in extradition proceedings, such as narrowing the charges upon which you're extradited. If there's a death penalty charge, perhaps the country won't extradite.
But that
And
is
also-
interesting. I mean, you think about it. He's in Pakistan. He's a citizen of Pakistan. And the United States, he's another citizen, wants him there. But he says, "No, I do not want to be extradited to the United States." And maybe he says, "I'm a Pakistani citizen." Isn't there some teeth there that maybe he,
I think you're pointing to the idea of waiver, that is, that he's waiving
No, I
his
wasn't
speech.
talking about waiver. I'm just talking about the whole circumstance of the government, the United States involved in it too, because he belongs to two different countries. And that's a factor on his part. It's not like he was trying to get himself extradited. He was trying to stay.
So extradition applies to both citizens and non-citizens. And so just because he contested extradition, if I'm understanding the court's question, it doesn't mean that he's asserting his citizenship. It's just he's saying that the government needed to abide by the process and the substance of the extradition procedure. My time has expired, but I do want to get out that this Article 4 provision of the extradition treaty, it is just a timing of surrender provision that can be waived by a sovereign. We've submitted cases, and the government points to Mr. Olson's declaration, but he's construing Article 4, and that's at page JA 158, paragraphs 30 and 31. He's not saying that at the time of the 2010 communication, they said, "We've looked at Article 4 and we're declining to extradite based on that basis." Thank you.
Thank you, Mr. Kamens, we appreciate you.
Thank you,
We'll come down and greet counsel and take up the next case.
Well, sir.
Good morning, Your Honors, and may it please the court. Rachel Wyrick.
Wyrick, I'm sorry.
Yes. Yes.
You may proceed,
Oh,
go ahead.
thank you, Your Honor. Rachel Wyrick for appellants. May I please reserve 3 minutes for rebuttal? This case is about concerned parents and community members who went to their elected school boards to criticize the board's handling of a specific security incident and were silenced for reasons the board itself cannot consistently explain. To make matters worse, the policy they now use to justify their actions is unconstitutionally vague. The district court got this case wrong in 2 fundamental ways. First, it ignored our unrebutted evidence of post hoc rationalizations and unequal
Identify
treatment.
the constitutional issue you are proceeding on. Is this, you mentioned the vagueness part. Are we dealing with the board for vagueness, or are we dealing with the as-applied viewpoint discrimination?
Both, Your Honor.
So which one, and they have different analysis, so which one are you approaching?
Yes, Your Honor. Sorry, I was doing a brief summary of both of them to explain how the district
Go
court.
specifically to the one that you
Okay.
think is a problem.
Your Honor, well, both are problems, and we can start with as applied if you'd like to discuss that. In this instance, the Supreme Court has said over and over again that the government may not regulate speech based on the message that it conveys. And here, that's exactly what happened. The school board wanted to criticize, the plaintiffs, our parents, wanted to criticize a school board about its handling of a specific security incident involving a student that had been reported on in the news. And the school board shut them down as soon as they started saying.
The issue was the naming of the student, wasn't it?
Well, Your Honor, there was no naming of the student. That was the reasons that the school board gave. They claimed that these parents were sharing information that could be used to identify the student or disclosing PII, but that's not actually true. And even the board admits on page 9 of their brief that they shut down one of these parents for saying the word him, which certainly cannot be used to identify
So the question
anyone.
here, you've got this policy, you do agree it is facially constitutional?
We are not
Policy.
pursuing a challenge to it facially, Your
Policy
Honor.
is good, and this policy says, okay, you can come to this school board, limited First Amendment type rights in a limited type situation, understood, and you can talk, but you can't criticize or attack individual students. That's not permitted. And so you had 5 speakers, 2 talk, and they kind of do it a little, and the third one stepped a bit more so into criticizing a student, didn't name the student, but there's only one person you're talking about here, and was going in the direction of doing that. And that's when the school board chairman, Ms. Mansfield, didn't stop it. And you say that violated the Constitution because it violated an as-applied viewpoint discrimination. It was as-applied viewpoint discrimination.
Yes, Your Honor, these, we're not contesting that the school board can place reasonable limits on the use of the forum, the school board forum. But when they do, they have to be applied equally. And we feel strongly that these parents did not criticize, target, or attack this student under any common understanding of the term.
So what if, I appreciate that argument. I think your claim is that, number one, it's not identifying information, and number 2, you're really criticizing the school board and not the student. What if we were to feel hypothetically, disagree with that, that while you may be aimed mostly at the school board, there's inherent criticism attacking, or I forget the other word.
Targeting or
Targeting this particular student. And given the context, everyone knows who it is. Do you have to win on those 2 issues, on the as-applied challenge, that it was not targeting and that it did not identify the student?
No, Your Honor, I believe we could win on either one. We did not target, criticize, or attack this student. He was not the object of these parents' remarks. There was no ad hominem attack. This court in Steinberg discussed a personal attack and described it as insults directed at or to an individual, and said that sometimes it can elicit a responsive discourse or a counterattack. That wasn't an issue here because they weren't directing their comments to a student. It would have been.
And they didn't, I don't think, at least October 8th, say that you were.
No, Your Honor, that's exactly the point. Throughout these remarks that these parents made, the school board interrupted them for commenting on a student or discussing a student in a way that disclosed or could disclose confidential information or disclose PAI. And even based on the school board's own standard of what that is, they did not come close to disclosing any identifiable information under the school board standard.
But I think isn't your argument that, I know you disagree that it discloses personal information, but maybe I misunderstood things, but I thought your argument was, they said at the meeting, you're disclosing information. And then they have a release the next day, and it talks again about disclosing information, and it talks about misinformation. And then they don't decide that this targeting, criticizing reason that is in the policy isn't mentioned until October 22nd. Is that
Yes,
right?
That's accurate. And even when they mentioned on October 22nd, they don't necessarily say that that's the reason they silenced these parents. They don't assert that until this litigation began. And, the comments that they made at the school board meeting about.
Well, I hear you there, but they're using the reason, they're talking about the prior incident. I mean, that seems a tad picky
Well,
to
they
them
also-
to say in October when they cite that they're not referring to
Well,
it.
they also mentioned a number of other policies at the same time, so it
Sure,
is.
you can
sure,
have
could
multiple reasons. You'd have the same argument, right? That
Sure.
if you came up with them out on your third try, there's an indication under the law that might be indicative of discrimination. But,
Yes.
all right.
Yes, absolutely. I mean, they gave some reasons at the start, which don't make sense in light
Now,
of
the
the
district
fact
court didn't mention the shifting explanations.
it did not.
Is it wrong? Does a district, don't we have law that says a district court doesn't have to mention every reason?
That is, yes, Your Honor, that's true.
This district court, I know you disagree with some of the decisions, but it seems pretty engaged. It's listening to the arguments, it's responding. So I'm trying to, I appreciate your argument that you have this shifting explanations. And I understand your concern that it wasn't raised. Why does he have to raise it? Why don't we assume that an engaged district judge who rules against you hasn't considered it and rejected it?
Your Honor, he said in his order, or at least he said on the record at the time he issued his order from the bench, his ruling from the bench, that the record had no evidence of comments that were specific to individual students. And we
Well, that's
presented.
right. And that may have been wrong because there was record of comments to individual students, and you pointed to those. But if the reason is targeting and attacking, I don't think there was any other evidence that was targeting, attacking, save for those that the school board says were no longer students or something like that.
Sure, Your Honor, but the district court established that the proper level of comparator here was not targeting, attacking, or criticizing. It was commenting or discussing a student. And that's in part because that's what defendant said on the
Well,
day of the.
he said that, but to be fair to him, he also said, he said targeting, he said identifying information, and I think he says, and violating the policy. Now, the policy includes this targeting stuff, so why don't we give him credit that he's got it on two grounds? One, that there's identifying, that you were providing identifying information. And if that were the only thing, then you might have a pretty good argument because you got other examples of that. But he then says, and violating the policy, which the policy talks about the targeting. Why don't we give him the credit for, invoking that issue, which leaves you with the shifting explanations argument?
Your Honor, I think we presented evidence that we did not identify this student. And as for the targeting, even if, it is either or, and he doesn't have to say all of his reasons, but the fact of the matter is that there was, we did not target this student. He construed it to be that way, but that's why we also have our vagueness claim.
Right.
Is that, under our common understanding of these terms, what these parents said don't constitute targeting, attacking, or criticizing. The terms are not defined. There's no guidance in the policy that provides meaning for what these terms are supposed to cover and what speech is actually prohibited by the policy.
So let me ask you about that. I think, the district court didn't really go into that. He just says, I'm bound by Steinberg and Davison, which don't mention vagueness anywhere. So I appreciate your argument there. I got a different question, though. Understand your argument that they're vague. This is not really about this case, but I just want to understand the principle. Assume you got a challenge to a vague statute, that it violates the 14th Amendment because it's unconstitutionally vague as applied, but under any definition, a particular plaintiff who's challenging it would fall within the meaning. You understand what I'm saying? So let's assume I think attack, criticize, I always can only get two of them. Let's assume those are vague terms, but however vague they are, your client's conduct, it applies here. I know you deny that, but assume it is. As a matter of law, can you bring a case if something is vague, but as applied to you as unquestionably within those words?
Well, Your Honor, there is the clearly prescribed doctrine that says, as applied to the facts of the case at issue, if it's, the speaker or the person has engaged in that conduct that's clearly prescribed, then no, they're barred from bringing a facial challenge or a vagueness challenge on behalf of other people. I think they could still probably bring it on behalf of themselves, though I think that they would probably be barred if but Holder is a great.
So we have to agree that it's vague as to you for you to be able to,
Yes,
you
Your
can see
Honor.
that?
And, Holder's a great example of this. There were the terms at issue there in the material support statute or training and personnel, and both of those terms were defined, first of all, and none of the terms at issue in this policy are defined. But the plaintiffs in that case actually used the terms of the policy, of the statute, to describe their proposed activity. Whereas here we're saying, absolutely not. The terms at issue in this policy rely on the subjective judgment of the person tasked with enforcing them. And, the definition of target, attack, or criticize, some of them refer to the other term for their definition. It's circular, and it's incredibly unhelpful for a person who is trying to figure out what this policy actually prohibits. It does not give fair notice to an ordinary person so that they can comport themselves accordingly. And the chairman's enforcement of this policy makes it even worse. She has sworn now in a declaration that the only reason she silenced these parents is because they targeted, criticized, and attacked a student. But that's not what they said previously. And so if we're to say that that's the only reason, does that mean that that policy also encompasses commenting on or mere reference to an unidentified student? That surely demonstrates its vagueness. And the lack of clear guidelines or explicit standards does not meet First Amendment criteria here for this case. So you're correct, Your Honor. I think that it would be prescribed if our parents engaged in it, but we disagree wholeheartedly that they did. They really were focusing their comments on the school board. And like in Steinberg, this court had a discussion about the fact that personal attacks are usually
You
irrelevant.
know what that red light means?
Oh, I'm sorry, Your Honor. I'm so sorry. I thought it was going close to it. I apologize. May I?
Go ahead and take 30 seconds to wrap up.
Thank you, Your Honor. All I was going to say is that this court has said that personal attacks are often irrelevant and that somebody can convey a message, maybe even more effectively without it. In this instance, there is no way these parents could have conveyed their message and their concern about the board's handling of this incident without discussing the incident. And the only reason the school board shut them down is because they did not like their message. They thought it was untrue and political. Thank you, Your Honor.
Wait a minute, is the amicus next? That's you? Okay. Mr. Eberstadt,
That's right, Your Honor.
good to have you with us, sir.
Thank you very much. It's good to be here. Now, may it please the court, I am Rick Eberstadt on behalf of the Commonwealth of Virginia as amicus. The Commonwealth has a strong interest in protecting Virginians' free speech rights and in making sure that school boards cannot unconstitutionally silence concerned parents. So in this case, we would ask this court to rule for the parents on their free speech claim for 3 reasons, all of which we believe show that the school board's actions were a pretext for unconstitutional viewpoint discrimination
I would
here.
think the Commonwealth has a sort of a mixed interest here. You've got your citizens, but you do want your school boards to be able to conduct it in an orderly way.
Your Honor, we do want the school boards to be able to conduct meetings in an orderly way, but we also want our citizens' free speech rights to be protected, and we genuinely do not think that that was what happened here. And there are 3 reasons that we think that's the
So which
case.
of the speech, on the constitutional violations as applied that you're addressing, or is it a vagueness?
No, yes, Your Honor, it is the as-applied that I'm addressing, and that is our amicus brief here is about the as-applied challenge, that we believe that the school board's rules as applied to these parents were applied in an unconstitutional way. And the first thing I'd like to point the court to, there are 3 reasons. The first is that the board directly admitted that they shut down the parents' speech based on viewpoint in their statement the day after the meeting. The second is that the board's justifications for shutting down the parents' speech has shifted repeatedly over the course after and the day after and over the course of the litigation. And third, because the board's own stated reasons for shutting down the meeting do not stand up to examination as having been applied even-handedly. Now, to turn to the first point, the day after the school board meeting, the board released a statement on safety, student privacy, and misinformation. In that statement, the board said, in explaining why they shut down the meeting, why they shut down the parents' free speech, they explained that it would have been, this is their words, irresponsible if they were to, quote, allow...
What is the viewpoint that's being discriminated against?
The viewpoint that's being discriminated against is the school board does not seem to like being criticized over and on this particular...
But it was allowed to criticize the school board.
Yes, Your Honor, but it does not seem to like being criticized on this particular issue based on these particular news articles.
The district court concluded that after the hearing, said the evidence is clear that is only when the plaintiffs veered into targeting to a specific student that they were interrupted. And it said the same thing in the written opinion. Is that clear error?
So, Your Honor, I do think that it is clear error because the district court did not seem to take into account, and regardless whether it took it into account or not, the accumulated evidence shows otherwise, the specific statement afterward that the school board issued, saying that the reason it had to shut down the meeting was because misinformation was being spread in the meeting, information that they go through in some detail against what they disagree about in the news articles that the parents were citing. They refer to the news articles as having been without full context or knowledge of LCPS's response. They say that local media may share inaccurate or incomplete information, and that when that happens, it would be irresponsible for the school board to allow this information to spread in this public forum.
When you're looking at the shifting explanations that Judge Qualibon alluded to, you have non-lawyers in a limited type situation with the school board, and they are articulating certain things. They say misinformation and the kinds of things that are listed here within this policy here. Do we hold them that you didn't specifically say under the school board policy 2528(3), it is required, da, da, da? I mean, the district court has made the determination that it was only when they veered in criticizing a student, a specific student, that they were then interrupted.
So, Your Honor, when the school board, admittedly, they are not lawyers, nor do they need to be. But though they are not lawyers, they ought to know their own
Are
rules.
those school board members paid, or are they just volunteers?
Your Honor, I don't know. Whether they are paid or are volunteers, they are a government entity, and they ought to know their own rules if they are
They
silencing.
pretty much get no money, even if they do, it's not,
If they
I
get
don't know,
paid,
any
it's
school
not
board,
much.
not in those little small areas get much money. So, these are people out here, just regular citizens.
Pretty
They
thankless
allowed the
job,
first
I'd
two
say.
to speak and what's going on, and as the district court says, it then veers into a specific student, and they were trying to, move it away from this. If you want to talk about a specific student, then you meet us later on, we talk about administrators and stuff on it. And apparently it's clear, at least I understand, the policy is not vague on its face, that it is facially constitutional, I should say. The chairman of the board is trying to keep peace in the meeting. It's obvious that the individuals there are upset. They're upset because of a specific student, which makes it difficult now. I would say that. How do you not talk about that specific student? But to do so would violate the policy. So apparently the people speaking realize this, and they don't call out the name, but they're calling out the student. And everybody know who the student is. And then, so we get into this, we end up in the Fourth Circuit, now we're arguing, you know, that you want to have a right to say these things because it's a viewpoint you want to say, but your viewpoint is to criticize the board, but you are allowed to criticize the board, right?
So, Your Honor,
We're allowed to criticize the board. It's a question of fact, I guess, as to whether did that veer into criticizing or targeting a specific student. The district court found that it did, and then put it in a written statement. And our review is clear error.
so, Your Honor, I see that my time has expired. May I
You
answer
go
the
ahead and
question?
finish. If you perceive that as a question, you answer it.
Yes, Your Honor, I did, and do have a.
What do you think about what I just said?
You're getting a lot of that today.
I didn't invent it.
Your Honor, I think that paid or not, I think that the school board unconstitutionally, it violated these parents' constitutional rights for 3 reasons. And one, the first one that I point the court to in response to that is in their own statement the next day, talking about misinformation, talking about they had to shut down this meeting because of unverified information spreading in it. They are entitled to their opinion on what is true and what is not. But the First Amendment does not.
The speakers are entitled to their opinions?
The speakers
They
are, and the school
entitled to their
board.
opinions. And the school board, I don't know whether they're paid or not in Loudoun County, Virginia, but where I grew up and was around them, they weren't paid. And I admired them for the service they did. And I was actually a school teacher one time for a while, and they weren't hardly paid either. And I admired all of them I worked with. So I just state that for the record.
But Your Honor, they are not allowed to shut down parents' views based on a disagreement of opinion.
But they're obligated to protect these students. That's what all of you should be doing.
Yes, Your Honor. May I answer that? May I continue to answer?
Well, you're out of time.
I'm sorry, Your Honor. Then we would ask.
Gave you extra time. Matter of fact, gave you 5 minutes to the Attorney General to come in here and criticize the board.
Then we would ask this court to
Thank
rule
you
for
very
parents
much.
on that issue. Thank you.
Mr. Bardo, Ms. Bardo, I'm sorry.
Either way, thank you.
Ms. Bardo, good to have you.
Good afternoon, good to be here, thank you. May it please the court, my name is Heather Bardo, and I represent the Appalese, the Loudoun County School Board, and Melinda Mansfield, its chair. I'd like to just get right to this as-applied challenge, because I think it's important for this court to focus on what was actually before the district court, rather than to be drawn into the arguments, which I suggest are new on appeal. On appeal, the appellant suggests that the school board engaged in viewpoint discrimination because the school board allowed other speakers to make, quote, reference to individual students while not allowing them to do the same. But referencing a student is not what caused the school board to interrupt appellant's speech. As the district court noted in its order, which is at JA 427, and I will quote, "The evidence is clear that plaintiffs were interrupted only after their comments targeted a specific student in direct violation of policy 2520A3. And the district court properly held that the appellants failed to identify a single other situation in which a speaker had targeted an individual student and been allowed to carry on."
So you, counsel, on that point.
Yes, sir.
You're referring to the order itself.
Correct.
Not the description of the ruling at the hearing.
Right, so certainly,
Because at the hearing, the district court never said that.
The district-
At the hearing, the district court said the record shows there's really no evidence of prior student-specific comments that were allowed or not interrupted by the board. And there plainly were examples where that has occurred.
Correct, but you have to read the district's court.
Okay,
the
I
di-
hear you. So you go to the order,
Well, not-
and your point would be, I think, that the other examples that were cited of identifying information were not criticisms or targeting?
Well, two things. Some of the other examples weren't even of current students, and of course, the policy talks about students, but
It
yes,
said-
as.
It said zero evidence. That seems, what he said at the hearing, I respect, look, he's doing things quick. I mean, I'm not trying to nitpick, but
But you
just
all-
as a matter of fact, that isn't correct.
It is correct, because you have to read that comment by Judge Nachmanoff in context of the entire colloquy that occurred during that hearing. And so when he said that, he had already talked to counsel for appellants about, well, wait a minute, you're saying that they're not targeting or criticizing this student, but let me ask you this, Ms. Wyrick. If you were the parent and they were saying that this kid had gang affiliations and all these other things and had been arrested and so forth, can you tell me in what world as a parent you wouldn't
Right.
have felt that they were targeted? So this is the conversation that then leads to his comments later. So I don't think you can cherry pick that piece of his comment out of the whole colloquy and say that he wasn't considering those comments to have been targeting. Did he say that in that specific phrase that has been pulled out and relied upon by Ms. Wyrick? Certainly not.
Well, does it really matter? I mean, if the written order says targeting, I mean, you read from the written order.
Yes, Your Honor.
I mean,
I mean, obviously, that was his finding, and he indicated in his opinion, short though it may have been, that he looked at everything. He looked at the video, he considered all of the evidence, and it was clear from the evidence that he viewed and that the court has before it, that these persons were not interrupted until they targeted the student. And I would submit that when you look at the actual video, that's accurate, because you look, for instance, at Ms. Miller. 228:17 is where her comments start. She comes in thrashing. She accuses the school board of betraying the trust of students and parents. She says they don't have their best interest at heart. She says they engage in unscrupulous cover-up, that they bury their heads in the sand, that they're heartless and they're soulless, and they're not taking care for the safety of children. I mean, she's saying about as nasty things, well, there have been nastier, but nasty things about the school board, and they don't interrupt her. They say, fine, you want to bash at us about the way we handle
Right.
safety issues? Bash away. They sit in silence. And it is only when she then goes into talking about the reassignment of the specific student, and she says, how many ticking time bombs are there like this? A student who poses a significant,
So do you, as I read your briefs, or brief, I recall, I think, and correct me if I'm wrong, that the board deems it okay if this incident were talked about without saying he or something like that. If there was a criticism that the school board is inappropriately reassigning gang members who carry guns, that would be okay.
Not only was it okay, it happened here without being interrupted. If you look at Ms. Michon's comments that start at 2:37:04, she's interrupted when she starts talking about the specific student carrying a concealed weapon walking to school. She's interrupted and then allowed to continue, and she redirects her comments in an appropriate way. And she talks about her concern with safety policies.
That's an important part of the case, as you indicated, and the district court made that finding, that it was when the plaintiffs veered into targeting a specific student. You gave the information that sort of supported the fact that they were allowed to criticize the board, but get more specific, be more specific. Where is it, what is the language in which they veered into targeting a specific student?
Right, so in the context of this case, where you can see in the record that there's been a recent news report, it's part of the record, where the student has been identified as a Loudoun County student with gang affiliation, who was carrying a weapon, arrested on the way
What
to.
was the specific language that was being said?
Sure,
What-
and
what
so.
were- What were the statements?
So-
We got the record, we knew what the
Yes,
record
sir.
said.
So for Ms. Miller, she said, how many ticking time bomb, this may be a bit of a paraphrase, but it's pretty close. How many ticking time bombs are there, like the reassignment of yet another student who poses a safety threat to this school? A student with violent gang affiliations who was arrested, on the way to school. This is veering into that very news article that was before, everybody in the jurisdiction knew about. The school board chair certainly knew who this was talking about. It had been well reported. We had a lot of people there to speak on issues related to this student. And so that's the point at which, when it identified that specific student with alleged gang
That's where
affiliations.
It gets fuzzy because you do want parents to talk about gang violence and when you allow things like that to happen. But the policy does prohibit you from dealing with a specific student. And I think the out that seems to be allowed here is you can talk about it, but we're not gonna do it in a public, this limited public forum. You can go to the officials and you can be specific about, I guess, about any student you
All
want to
day
in
long.
there. But and that's the difficulty we're running into now.
I don't.
The word politics doesn't come up, but there's always the politics of meetings and people want to make certain statements and you're really making them you're interested in it, but you're really trying to get an audience for it too. And the interest of the board to limit how this board is going to be used as a vehicle against a student or a person there. The parent has a concern, but also the public has a concern of it. How do you keep that? And at the end of the day, it comes down to a court determination, did that happen? And when the district court makes a specific statement and says that's when it veered into that, they were interrupted. But you could criticize the board. You veered it, you could do it. So that I'm asking a question. Is that your position in terms of how this is coming down? But you do recognize the difficulty that we're put in, and as well as courts and parents. And maybe if you had the more specific statement, we got a policy here that says this, that, I guess that would have made it clearer. And we think you are violating that policy. Would you not do that? And that's hindsight, but it's also to be informative on the next time this comes up for school boards and others that, give the policy, state it up front. And then it may be a debate as to whether you're going back or forth, but it seems to me on a clear error sort of situation is you now have given them notice, don't do that. We don't mind you criticizing us, but don't bring up specific students or specific acts that identifies a student.
Right, and you have to remember that at the beginning of the public comment session, as you can see on the video, that Ms. Mansfield, the chair of the board, went over the policy, and when she talked about the particular provision and about not talking about individual students, and if you had a concern with any individual student, that you had these other means to bring them to the attention of the board. What she's reading from is exactly this policy, which is 2520A, the section that says, speaker comments that target, criticize, or attack individual students are not permitted during public meetings. Speakers should communicate these concerns privately to the school principal or an appropriate school official. So
This was a regular public meeting of the board. It wasn't one for that specific purpose, was it?
No, but at a regular public meeting, every single public meeting that the Loudoun County School Board has, at least as of now, they have had public comment session. At the beginning of every public comment session, they go over 2520 policy. It's not only.
Required to do that?
They're not required to do that, but they do that as a matter of course to remind people of their obligations, to be civil, to have decorum.
They open the meeting with the public comment session?
They don't open it. It's done about, this was done about 2 hours into the meeting. It's done on the agenda where it fits.
It's on the agenda, all right.
Yes, sir. And so,
But once you open it, you give people a chance to comment. You do have this obligation to allow them to speak freely. That is definitely there.
with limitation, right?
So,
Because it's a
with
limited
limitations.
public
That's the
forum.
issue that we're confronting here. And, however this thing comes out, it needs to be clear. You don't have to do it, but if you do it, you've opened it up, and you got to give people a chance to speak. But I say I think the better way, and because I think one of the important things is to give guidance on how these things are, because these are non-lawyers. They didn't have you there. If they had you there, wouldn't have had this problem. Or if they had the other side, would have had this problem. Well, maybe you were, I don't know.
I was not.
But You know, so I think at the end of the day, we've got to parse out, well, when is it that it veers into a policy, but you didn't state it specifically there. So how do we deal with that?
But what I'm saying to you is, I think they don't have to state it precisely. They don't have to cite it by line and verse. She has said at the beginning of the public comment session, this is our policy, and not only did she say at the beginning, it's part of the agenda, but she said it at the beginning. You can view it in the tape recording. She goes through this policy. She talks about this particular provision, which doesn't allow you to talk about individual students. When they start to,
What provision of the policy says you can't talk about individuals?
it says you can't criticize, attack, or
That's a-
target.
Yeah, well, that, yeah.
Yes.
I mean,
There's no provision that says you simply can't mention a student, so I
Well-
didn't mean to suggest that, Your Honor.
agree, and, but it was not until October 22nd that the school board, moved from identifying students to targeting students. Now, I get the point, they're not lawyers, I understand your issue, that may be enough, that may be not enough, but it's accurate, I think, to say that the school board's comments were not about targeting, they were about identifying. They said that over and over until you got to the, next meeting.
I'm not going to argue a point that is not arguable.
Yeah.
I mean, obviously, that's not the word she used. Is it regrettable? Would she wish she had used those words? Sure, but I think in the context of her having gone over this section, which does talk about speakers should communicate concerns about, where it says speaker comments that target, criticize, or attack individual students are not permitted, communicate these concerns to.
What about, I'm sorry, go ahead
Sure.
and finish, I didn't.
No, communicate these concerns to the principal, and then when she interrupts them and says, you're not going to talk about these individuals, I think it's disingenuous to claim that nobody knew that's what she was talking about, which is what I hear now, because I will
Yeah,
tell
but
you.
But they went then the next day, where they're not in the heat of the moment, they're going to the formality of a written statement.
Right?
So this is a little different there, the pressure, the time pressure or whatever it is not the same, and they've written it out. People probably reviewed it, and not once do you say target, criticize, or attack. You say identifiable information then, and you add misinformation.
Right,
And then you get to, 13 days later, they have another meeting, and they identify the targeting policy. And I understand your point on that. The difficulty, though, is, or maybe you can help me with this. Is it your position that the extent of targeting, criticizing, attacking those that it took place on October 8th was materially different than what took place on January 30th, 2024, when they had the complaints about the sexual, misconduct or sexual assault, I think?
You're talking about the prior student.
Yes,
The policy would have applied. Ms. Mansfield would have had no ability to tell somebody not to talk about somebody who is no longer a student.
So the January 30th, 24 was a prior
That's a prior
student?
student, and you can see it in the affidavit or the declaration of Ms. Mansfield that we submitted in the district court. She would have loved to interrupt that conversation,
your
but she
br-
didn't because the policy wouldn't permit
I
it.
thought your brief was that didn't target an individual student. I thought your position, your brief about the January 30th, 24 was that it didn't target. And so my question, and maybe there's an additional reason that it's
Yeah, Your
not a
Honor,
student.
my belief and understanding and recollect, I know I'm accurate in my understanding of that because I know which student that was. I'm
Right.
very familiar with that incident. That person was no longer a student. If you look at the declaration filed by Ms. Mansfield, the reason she did not interrupt that statement was because that person's no longer a student.
And I thought that was the position with the folks who, where there was discussion about the students who wore stoles wearing the Palestinian flag, that was a graduation, they weren't students.
Those were no longer students either, nor did it target them or target or attack those students. So that was the position with respect to that.
Well, I mean, okay, so you think that, the discussion of that is not
That is-
targeting students?
No, we do not believe that was targeting students. That was targeting the school board member for failing to shake the
Shake
hands of
hands.
those people who were no longer students.
Okay. And so the January 30th incident didn't involve a current
It
student?
did not, Your Honor.
Okay, I appreciate you clearing that up.
And while I have some time, I do want to address this media release because I think there's been a lack of faithfulness to the text of that when it's been referred to by the Commonwealth and by the appellants. I think they take out of the text of that what they think is helpful to their position without actually being faithful to the full text of it, because what it says, in part at least, the part they don't pay any attention to, is at the October 8, 2024 meeting of the Loudoun County School Board, a number of individuals sought to discuss what was reported in the media and discuss a specific student despite repeated requests.
Is that part of the trial judge's findings or in his hearing? I mean,
He did not look to that, right?
I'm looking at our review. I mean, we can look at media release, we can listen to what people talk about, but our review is a clear error, one.
I don't disagree with you. I was,
Dealing with that, I mean, we can go round and round. It's not a political forum where we're gonna try to work it out one way or the other, what the media is saying, what not. We're not trying to decide that. We're deciding a constitutional issue here.
I don't disagree with you.
And
I
we
was
don't
just,
limit ourselves to do that.
I was just trying to answer Judge Quattlebaum's
I
question
understand,
about the
but
release.
because, Judge Quattlebaum, is there something further you want to talk about on media? I don't want to.
No, I'm
You sidetracked me,
satisfied.
so
I didn't want to interrupt if it
No,
is,
no,
because
she-
I didn't
well,
perceive it to be
we-
that way.
no, no,
But
no.
But I do have a question with regard to the shifting explanations.
Yes, sir.
Because you allude to the fact that just before the public comment period commenced, that the Chairman Mansfield did specifically allude to that policy and say not to target, criticize, or attack individuals. Is that true?
She alluded to the policy and said that they should not talk about individual students. She did not during that session. She clearly was alluding to the policy because she was talking about that, the civility and decorum, reminding them to comply with the public policy comment sections. She did not, in that statement, use the words target, criticize, or
And
attack.
that statement is which one? October 9th? What-
October 8th preceding the actual,
Yeah, but the statement was October 9th, and the meeting was October the.
October 8th.
the statement you're talking about is the beginning of the October 8th
Yes.
meeting. There was a subsequent written statement that.
The media
on-
release.
On the 9th.
Yes, Your Honor.
Yeah, and that's all I was asking. You referred to that statement, and I was just wanting to make sure we knew what I knew, what that statement was. And that's,
Very well.
I think,
I never got to the void for vagueness piece. I see my time is over. I'll answer any questions you may have. Otherwise, I'll rely on my pleadings.
thank you very much.
Thank you.
Thank you, Your Honors. Just briefly, first to clarify, and as counsel just noted, there is no policy against commenting or referring on an unidentified student. And there is no evidence in the record that this student was identified in the news articles or at the school board meeting. He is currently unidentified. In relation to that, the identification is very important here. Even if you find that the plaintiffs, the speakers, targeted, criticized, or attacked a student, it has to be somebody that was identified. That's what the school board has said. And under their own standard, which we discuss in footnote 3 of our brief, there is no way anything they said could have allowed anyone who didn't already have personal knowledge of the relevant circumstances to identify this individual with reasonable certainty. And that's what their policy requires. So there's just no way that anybody identified this student. I think a lot of this discussion, though, is even being had because of how vague this policy is. There is no definition about what target, criticize, and attacks means. There is no standard for the chairwoman's application of this. You can see from her interpretation of it that it does not comport with common understanding of what target, criticize, and attack may mean. Even in their current brief before this court on page 38, they say that plaintiffs were interrupted when and because they commented on an individual student. If this policy against targeting, criticizing, and attacking,
It says individual students, not identifiable students.
That's correct, Your Honor, but since the beginning, the school board has said that they were interrupting our plaintiffs and causing them to move on because they were identifying a student and disclosing PII. But you're absolutely right, and, you know, to the extent that it says individual student, what the school board means is identifiable, it should say that. You know, because what constitutes restricted speech under this policy is left to the subjective view of the chair, it invites arbitrary enforcement, and we can see that in a number of the examples that we've given, and I'd like to speak just briefly to the distinction between former students and current students in these examples. All of the instances and all of the comparator evidence that we provided happened when these students were students at an LCPS school. And, you know, surely the school still has an obligation to maintain confidentiality about those students. Surely
So
that.
is it your position the January 30th, 24 meeting involved a student who was a current student?
A student at the time. He was no longer a student at the time the speaker discussed it, but he was when the incident occurred.
Okay.
And surely it's not the case that as soon as a student leaves the system or walks out the door, that the obligation to maintain confidentiality about that student dissipates. And if this is really about, may I just finish my point very briefly, Your Honor? If this is really about, if this is not about privacy and instead about disruption, it's unclear how allowing remarks about former students is any less disruptive than allowing remarks about current students. Thank you, Your Honor. We'd ask that you enter a preliminary
Thank you.
injunction.
We appreciate each of you's presentations. We'll take the case under advisement. And with that, Madam Clerk, we'll adjourn for the day.